I'm pleased to introduce our facilitator this morning, Benjamin Miller. He's worked in the Nonprofit Law Ontario project since 2017, where he has worked to meet the legal needs of nonprofits and charities through clear, practical, and accurate education and information. And in this capacity, Benjamin has developed and delivered dozens of workshops and answered thousands of nonprofit law questions. So I'm going to hand this over to Benjamin's very capable hands. He has a presentation that he will walk us through, and I will monitor for questions, and there are going to be some natural breaks throughout the presentation where we can field your questions as well.
It's a pleasure to be here with you today to discuss ONCA. I'm sure everybody's favorite topic here, but maybe I can win you over by the end. First, we're going to discuss some of the new elements in this law. What does this actually mean for how nonprofits govern themselves? Secondly, what steps are involved in the transition process? In particular for small organizations, for those that may not have all the capacity or legal help, external legal help in the world, how do you navigate this process? And then finally, what resources can we offer you? What's free out there? What will help make this as easy as possible? And hopefully, by the end, I'll make the case that this can be a constructive process for your organization, not just so much distracting red tape, because you do have important missions to get to. I note that although I'm presenting this to you today, this is really the product of dozens of times that this session has happened, with 4,356 recorded participants, all of whom have contributed to crafting it into what it is, to their questions and their participation. And in that spirit, I really hope that you today will bring your questions as well, because I learn a lot, everybody else learns a lot, and future participants in this session will learn as a result of your contribution. So I'm from the Ontario Nonprofit Network. We're an umbrella organization advocating for a more enabling policy environment for the nonprofit sector, including arts organizations. So we seek shared solutions like this. But this project was stewarded by Community Legal Education Ontario for many years and funded for the past couple of years by the Law Foundation of Ontario. If you, your staff, volunteers, the people you serve, need legal information on a range of other topics, employment law, human rights law, tenant law, etc., I encourage you to check out stepstojustice.ca. All right, so as a lawyer, I'm very fond of disclaimers. I have not one, but 4 disclaimers for you today. Firstly, everything I will share today is general legal information. It's not tailored legal advice. And that's not because I don't want to help. It's because I cannot help effectively without having your governing documents in front of me, without knowing the history and particular culture and values of your organization. I cannot effectively advise you. So when I say something is general legal information, I really mean it. Secondly, today is a high-level overview of Ontario's Not-for-Profit Corporations Act. It's intended for provincially incorporated nonprofits. Okay, if you are federally incorporated under the Canada Not-for-Profit Corporations Act, or if you are unincorporated or you're a co-op, this session is not for you. Okay. What this session isn't is a comprehensive treatment of ONCA. We have lots more resources on our website, which I'll point you to at the end of this presentation, and we have some more in-depth sessions that you can sign up for. If you sign up for a newsletter, you'll hear or see or notice future opportunities for this session, for a more in-depth session. Disclaimer number 3: this presentation is about law. It's not about best practices. Okay, just because something is legal does not make it a good idea. All right, my job is to highlight for you the options that are available to you for how you structure your governance. Your job is to decide what actually makes sense for your particular community. And then finally, today's about law. It's not about your funders' expectations, particularly when we come to discuss the new rules around financial review. You'll see that there's new flexibility in the law, and your funders may not have caught up to that flexibility. Many, when ONCA took effect in 2021, did start to change their practices, but not all have. So this may be a conversation for you to have with your funders to make sure they have this new information. Okay, so with that, I want to thank Charles for his detailed and thoughtful land acknowledgement. And I want to build and connect that land acknowledgement to the specific conversation we're having today by contrasting two sets of treaties that Charles alluded to. On the one hand, the Dish with One Spoon Treaty, embodied in what's called in English a wampum belt, and the Treaty 13 on the other. So the way that the wampum belt works in practice is it's brought to important meetings between the parties with a speaker, and the belt, so to speak, speaks through the speaker, reiterating the terms of the relationship, which naturally changes over time as the relationship between the parties changes. As Charles said, it's all about the relationships. On the flip side, Treaty 13, with the Mississaugas of the Credit, the first attempt at which was made in 1787, by 1805, the then Lieutenant Governor was so disturbed by its questionable legality, he had one of his staff go look for it. Note, he didn't know where a copy was. They had to look for it. As I've read the story, his staff found it in a shed somewhere, one copy, and it was a blank deed with signatures from other pages attached. Okay, it didn't meet any standard of legality whatsoever. Why do I share this with you today? Because very often I meet nonprofits who relate to their governing documents more like Treaty 13 than like the Dish with One Spoon, meaning they write it down on paper because somebody told them they had to. They file it away, maybe not to look at it for decades, until somebody gets nervous about something. There's some kind of dispute. They pull it out, maybe literally blow off the dust, only to find that what's on paper has nothing to do with what they do in practice. Okay, my hope, if you take nothing else away from today, it's that the ideal we're striving for is much closer to the Dish with One Spoon. It's relational, it's iterative, it's integrated into our ongoing processes. It's not just about what we write down on paper. It's not just about updating our governing documents. That's a great first step, but it's how we take what we put in our governing documents and actually integrate it into our practices. All right, so some key terms. ONCA. What is ONCA? So Ontario's Not-for-Profit Corporations Act is a piece of corporate legislation, meaning it governs things like who are the members of your organization? How do you take votes? When and where do you have meetings? What are the processes of those meetings? What records do you need to keep, etc.? Ontario's Not-for-Profit Corporations Act replaces Ontario's Corporations Act for most nonprofits in Ontario. It took effect on October 19th, 2021, so it's already in effect. But right now we are in the midst of a transition period ending soon on October 19th, 2024. Okay. So today's session is about updating our governing documents so our rules of governance reflect the new standards under ONCA, ideally before October 19th, 2024, although I'll say more about that later. Governing documents. What do I mean by governing documents? Generally speaking, from a corporate law perspective, there are three kinds of governing documents, and as I'll explain, we're only really talking about the first two today. Number one, your letters patent. This is a document that you didn't create. The government of Ontario would have created it when you first became incorporated, and they would have sent it to you. These are generally short documents, so don't worry if yours is short. It would include details like the name of your organization, the purposes of your organization, your founding directors, your founding address, and other special provisions you may have asked for at that time. Letters patent are now referred to as articles, or more specifically, articles of incorporation. So when you see that term online, articles or articles of incorporation, know that it refers to your letters patent. I'm going to use the term articles throughout today. This change in terminology does not require you to do anything. It's just a change in terminology. Number two, bylaws. You may have another name for this document. You may call it a constitution, your governing rules, your community covenant. You may have many other names for this. As Shakespeare wrote, a rose by any other name would smell as sweet. It's not about what you call it. It's about what's inside. If this document has your rules of governance, such as what's the size of our board, how do we take votes, where and do we have meetings, where do we keep our records, things like that, and the way you've approved it in the past is by going to board meetings and having the board approve it, and going to members' meetings and having members approve it. Generally speaking, that document from a legal point of view is going to be referred to as your bylaws, even if you call it something else. So I'm just going to use the term bylaws to simplify things. And then finally, there are policies. nonprofits are welcome to have all kinds of policies: intellectual property policies, privacy policies, volunteer policies, equity policies, harassment policies, you name it. You are welcome to have all these policies. ONCA does not have a lot to say about these policies, which tend to be more operational and detailed in nature. We're only really talking about your articles and your bylaws today. Key roles within your organization. From a corporate law perspective, there are 3 key roles in your organization. Of course, it takes many more kinds of people and many more roles to make a community work, but from a corporate law perspective, these are the 3 key roles. Number 1, your members. Members are to a nonprofit as shareholders are to a for-profit, meaning in the same way that shareholders own a business, your nonprofits control, your members control the nonprofit. Okay, it's not that they own it, but they do control it. Ultimately, the nonprofit answers to whoever its members are. And yes, pretty much all nonprofits in Ontario are required to have members. So who are these people? The answer is they are whoever you say they are. You may say anybody in your particular catchment area is a member. You may say only the directors are the members. You may say only the founders are the members. You can come up with pretty much whatever definition of membership you want. You may define it based on your community. For example, an Indigenous, Black, or a particular community of color. There are lots of ways that you can define membership, and it's really up to you to define this membership. Members have important powers, such as electing the directors or removing the directors. They have their approval, as we're going to see, is required if you want to make any changes to your governing documents. If you want to sell major assets or close the organization, you're going to need your members' approval. So who the members are is super important. Next are your directors, also known as the board. You may have another term for this group, such as the executive. It's that group of people who are ultimately responsible for overseeing the work of the organization. Or in the case of a volunteer-led organization, they may actually carry out the work. But the bottom line is, from a legal point of view, this is the group of people where the buck stops. They are accountable for the organization. Okay. Now, they are generally elected by the members. They exercise their power by coming together, typically at board meetings, and passing what are called board resolutions that are then binding legally on the organization. And then thirdly, there are officers. So examples of officers may be president, chair, co-chair, vice president, vice chair, secretary, treasurer, etc. These are all pretty conventional names, but the truth is you can come up with whatever officer titles you want according to whatever traditions are most reflective of your community's values, and you can give these officers the job descriptions that make sense for you. So don't feel bound to these titles, chair, secretary, treasurer, just because that's how many organizations do it. Often, I meet nonprofits who use the term directors and officers interchangeably. This is because often they're the same people, but they don't refer to the same thing. They are 2 different roles. Whereas the directors, as I mentioned, are elected by the members. By default, the officers are appointed by the board. Now, when I say something is by default, I mean that this is the rule unless your governing documents say otherwise. So by default, your officers are appointed by the board, okay, not the members. And secondly, whereas the directors, as I mentioned, they come together to make decisions collectively for the organization, the officers have individual jobs and they have the individual powers they need to do that particular job. Okay. So your members, directors, officers could all be the same people if you wanted, but they could also be different people. Regardless of whether they are the same people or different people, they are 3 different roles with 3 different sets of rules that apply to them. This is important to get clear because a lot of legal issues stem from confusing the fact that these are 3 different sets of roles. All right. Why care about the ONCA? You're here, obviously, so on some level you care about the ONCA, but perhaps I can motivate you more if you currently don't care so much about the ONCA. Number 1, ONCA represents an opportunity to revisit your governance. So if you haven't looked closely at your governing documents, if you don't really know what they say, or if you came up with them a while ago and the organization has since significantly changed, then beyond the minimum that ONCA requires you to do to change over your governing documents, the opportunity to read through them and understand them and ask yourself the question, does this still make sense for our organization? That really, I think, is where the value lies, to really revisit your governance so that your structures of decision making can help improve your organization. They can be an asset for your organization as opposed to so much annoying red tape. Number two, some new things are possible under the ONCA. For example, how we define who is eligible to be a member. It's become much more flexible, and we'll talk about that later. There are new flexibilities in how we do financial review, so that might actually save the organization some money. Number three, funders may ask, not a particularly inspiring reason to care about the ONCA, but it is true. I heard recently that OTF is asking funding applicants to submit their governing documents and specifically to say whether or not the governing documents are compliant with ONCA. So this might be relevant for some upcoming funding applications you have. And then fourthly, to avoid confusion later on. Okay, so as I promised earlier, here I'll talk about what's happening at the end of that 3-year transition period. So I mentioned earlier, ONCA took effect on October 19th, 2021, and there's a transition period ending on October 19th, 2024. What happens then? Don't worry, nobody is getting fined, nobody is getting penalized, no organizations are going to disappear out of existence. What's going to happen is an organization's governing documents will be considered to automatically transition over to be ONCA compliant. That doesn't mean your documents will magically change. What it means is that what's written down on paper may not reflect what your actual rules are at law. That's not the end of the world, but it is a confusing situation, and it requires an added layer of analysis to figure out what are our rules actually now that ONCA has changed. So ideally, organizations will want to try to update their governing documents and approve those changes, and we'll discuss that in the latter part of this presentation before ONCA, the ONCA transition period is over on October 19th, 2024. But here are two reasons I think you absolutely do not need to worry. As I like to say, there are many better reasons to lose sleep at night these days. Number one, there are no ONCA police. It's nobody's job in the government to knock on your door and ask you, have you complied with ONCA? Have you complied with your bylaws? So you may wonder, and I've gotten this question at workshops in the past, why care at all? Why even bother with all of this if nobody's asking? So there are a couple of reasons. The more legalistic reason is the way ONCA is structured, the members of your organizations, your directors, your officers do have rights under the Act to take your organization to court if they believe things are not running well. Now, this rarely happens. To give you a sense, there are around 60,000 nonprofit corporations in Ontario, and on Canley, which is not a comprehensive, but it's a pretty good public database of cases, over the last 30 years, I've been able to find not more than 100 cases on corporate law. So 100 over 30 years out of 60,000 organizations, that's not very frequent. So litigation is possible, but most of the time things get resolved outside of litigation because who has the time, who has the money? If you really want an organization to succeed, why would you take them to court, etc. But when it does happen, it's very destructive to an organization. And it really tears apart communities, and it's, everybody agrees it's a waste of their time, money, and it's quite sad to see. The more constructive reason about why I care about the ONCA, if there are no ONCA police, is that these structures and frameworks, agreeing with to them ahead of time, gives you something to fall back on when there is a dispute, which is quite normal within a community and can be quite healthy if it can be handled productively. But if there aren't those frameworks in place, as I'm sure people here know, disputes can get out of hand quickly, and it can be quite toxic to a community. Excuse me. Another reason why nobody needs to worry about the ONCA is that it's really not a major overhaul. Yes, there are many small changes here and there, but if you're familiar with how governance ran under Ontario Corporations Act, the previous law, you'll find that it is broadly similar under ONCA. Okay, so with that, I'm going to pause here for questions to see if there are any other any questions about anything I've said thus far.
I don't see anything in the chat. If there's any questions you'd like to share in the chat, or if you'd like to unmute yourself. So far, so good. A question that occurs for me, Benjamin, is having worked through this with some not-for-profit theater groups, it does trigger some really good conversation. And as you said, people revisit and become familiar with the documents. Do you have any thoughts on how to engage members to become more aware? Because often they're for very different reasons and may not be aware of their role or what some of the bylaws of their organization even are.
Yeah, that is a great question. And a very fundamental question about the state of civil society today. So a couple things. So number one, people become members for all kinds of reasons, and they may have no interest in being part of the governance, or they may not even realize it's an option to be part of the governance. So one thing an organization can do at the front end when it's signing people up as members is explaining to people exactly what that means. Does this person genuinely want to be part of the governance or not? Organizations are free to create other categories such as supporters or patrons, or you name it, come up with whatever word you want other than member, to define people who want to support the organization but don't necessarily want to be part of its governance. So, getting clear at the outset with one's community, this is what we belong to you, in a manner of speaking. Do you want to be part of overseeing this organization, making decisions for it, being part of the collective democratic process of ensuring this organization continues in the right direction? And the answer may be yes, or the answer may be no, sorry, I'm busy. I've got lots of other things. This isn't what I'm interested in, and that's fine too. So there's some work to be done at the front end to make sure they really want to be in the room. Secondly, once they're in the room, doing the most we can to make it meaningful and not just procedural legalese is also important. So in California, there's an organization called I can't believe I'm blanking on their name. I can't remember the name, but they've created a set of bylaws in the form of a comic book. And they did this in order to overcome linguistic barriers with undocumented migrants in the context of California who may not speak English or have high levels of literacy in English. Now, this has never been tested in Ontario, but there really aren't specific requirements about what your bylaws need to look like. They don't have to have Roman numerals, for example. They don't have to have all that caps lock, right? That makes it so intimidating and like just walls of text so that people tune out before they've even seen what rights they have in the document. So there are lots of ways, and I think artists are well positioned to do this. There are lots of ways to reimagine what governing documents look like and what they feel like for members, to reinforce that message visually, that this belongs to you. We're trying to empower you here. These are your rights. We want you to participate. So all of that is before we even get into the question of what the content of those documents are. Thank you. So once we get into the content of what those documents are, for example, do we have all of our meetings in person? That might be a great way of placemaking if that's relevant to the organization. On the flip side, that may be more inaccessible. Right. So depending on the geography and capabilities of our members, making things hybrid or making things virtual or making over the phone or whatever, having a set of governing documents that already makes it as easy as possible for them to participate lowers the barriers so that when we finally get to the conversation with them, we can imagine all the reasons they may not want to or not be able to participate. And we can say, actually, we've thought about that. We've thought about that, and we've taken you into account and so on. And that makes it as easy as possible for them to say yes. These are just ideas. I throw it out to the crowd. Other things that people may have done here to make their organizations more inviting to their members. Feel free to put examples either in the chat or to unmute. And if you need a moment to think about it, that's totally okay.
As people are thinking, I think that's a great suggestion, to think outside of the box, so to speak, and thinking about accessibility, depending on what your membership may be and what interests the particular group. I know in my case, a lot of artists that are based in theater, so they're going to be thinking along the lines of scripts and things like that. So you've given me certainly some great thoughts about how to revisit.
I love it. You've mentioned placemaking. I've been thinking about how audiences, community have a say in bylaws. Yeah, absolutely. And, that could be a defined role in terms like they could be made members, or it could be a totally new category. Meaning, I've set out 3 kind of defined roles in the law, but the truth is nonprofits are welcome to create whatever other categories of stakeholders they want and to make themselves accountable to those stakeholders in their governing documents in various ways. All right. Thank you for that wonderful question and opportunity to discuss some really fundamental issues. So, what's new in the ONCA? There are many smaller things that are new in the ONCA, but I'm going to focus on 3 high-level things. A new concept called the Public Benefit Corporation, financial review standards, and a new tech that went online at the same time as ONCA called the Ontario Business Registry. Okay, so public benefit corporations. So it used to be under Ontario's Corporations Act, all nonprofits faced pretty much the same set of rules, charities, some exceptions. Now under ONCA, for starters, all nonprofits face the same set of rules, but then some nonprofits face some additional rules. So that raises 2 questions. Who are these nonprofits and what are these additional rules? So these nonprofits are called public benefit corporations. And there are 2 ways that your organization may come to be considered a public benefit corporation. If your organization is a charity, then it would automatically be a public benefit corporation under ONCA. If your organization last year received more than $10,000 in grants or financial assistance from government, either federal, provincial, municipal government, or an agency of government, such as the Ontario Trillium Foundation, or gifts or donations from sources other than your members, directors, officers, or employees. Okay, basically members of the public who don't have a formal legal relationship to your organization. So if last year you received more than $10,000 combined from all the sources I just mentioned, this year you're going to be a public benefit corporation. And you'll do that determination every single year. Now, for arts organizations where a major part of your revenue may come from sales of, for example, tickets or admissions or something like that, I'll just note that doesn't count towards this amount. That is not a gift or donation. That is a fee for service or a fee for goods. Okay, this is talking about money that is given to you, not in exchange for anything, whether it is from government in the form of grants or loans or something like that, or from members of the public, whether they're individuals or foundations, in the form of gifts or donations. So if you're a charity or you meet those funding specifications, there's some additional rules for you. What are these rules? Number 1, if your organization dissolves, and that means it ceases to exist as a legal entity, or basically you're closing down. So the first thing you need to do is pay off all your debts. Once you've paid off all your debts, if you have any property left, and I'm using the word property here in a very broad way, I mean your intellectual property, I mean your equipment, I mean your props, I mean your cash, I mean, really, it's very broad. Okay. If you have property left after you've paid off all your debts, the question is, who gets that property? And for a regular nonprofit, the answer is anybody that you specify in your articles. You can put what's called a dissolution clause in your article saying, this is what's going to happen to our property if we dissolve. You could say it'll go to another nonprofit. You could say it'll go to the members. You could say it'll go to the audiences. You could say it'll go to the community. It's entirely up to you. For a public benefit corporation, the answer is more limited. A public benefit corporation, if they're a charity, can only distribute their property to either government, federal, provincial, municipal government, or an agency of government, or to another registered charity with similar purposes. If you're a public benefit corporation that is not a charity, you could either give your property to government, federal, provincial, municipal government, or an agency of government, or to another public benefit corporation with similar purposes. So you could have a more restrictive rule in your articles. You could say, we're going to give it to this particular registered charity or this particular public benefit corporation, but you can't have a broader rule than that if you meet the status of a public benefit corporation. So that's rule number one. Rule number two, you may be surprised to find out that a regular nonprofit under ONCA, any number of its directors can be employees. Now, they need to follow conflict of interest rules, and your bylaws could prohibit this, saying employees are not allowed to be directors, but the default is they are allowed to be directors. Again, remember my disclaimer, there's a difference between law and best practices. Although it may be legally allowed, it would certainly be a red flag for many funders, and there are all kinds of other complexities that can result from doing this. But I'm here to inform you of your options, and the bottom line is ONCA does allow for a regular nonprofit the directors to be employees of the organization. However, if an organization is a public benefit corporation, only up to 1/3 of its directors can be employees. If you are a charity, the rules are even more restrictive because you have to follow charity law as well. And the situations in which an employee is allowed to be a director of a charity are highly limited and defined by the guide called Payments to Directors and Connected Persons, published by the PGT. So I've put that in the chat. And that guide sets out the limited situations in which it's allowed and the procedure that has to be followed if it's allowed. Bottom line, a regular nonprofit can do it unless your bylaws prohibit it, but you still have to follow conflict of interest rules. Public benefit corporations can do it up to 1/3 of their directors can be employees. Charities can almost never do it. The third difference in rules has to do with what kind of financial review you're expected to have when you're required to have an audit or not. And that is the next topic we are going to talk about. Financial review standards. So the starting point is all nonprofits are required to get an audit each and every year. That's not new. That was true before under Ontario's Corporations Act. What's new is that some nonprofits have the ability to pass what's called an extraordinary resolution and waive the audit. Some need to get what's called a review engagement instead. So that raises a few questions. Number one, what's an extraordinary resolution? Number two, who can pass one to waive an audit? And number three, what is a review engagement? How is it different from an audit? Okay, so an extraordinary resolution. An extraordinary resolution is a resolution typically passed at a members' meeting, but in contrast to a regular resolution or an ordinary resolution, what makes it extraordinary is that you need 80% or more of the votes cast at the meeting to support the resolution. So just to clarify, it's not 80% or more of all your members. It's not even 80% or more of all the members at the meeting. It's 80% or more of the votes cast at the meeting. Okay, if you can pass that, then you can pass an extraordinary resolution. If you, for whatever reason, you aren't able to call a members meeting or don't want to call a members meeting, then if you can get a unanimously supported written resolution outside of the meeting, that's fine too. So unanimous means that anybody who would have been entitled to vote on it signs on to it. either literally or electronically, or we were talking about accessibility earlier. Electronic signatures are actually quite flexible what counts, but some form of a signature, but it needs to be unanimous. Okay, so let's say you passed an extraordinary resolution. Who can waive an audit? So for organizations with annual revenue under $100,000, and I'll just note, when I say annual, I mean your fiscal year, and when I say revenue, I mean all the money you take in, whether it's from donations or sponsorships or sales or what have you. For organizations with annual revenue under $100,000, by default, you need to get an audit. You can pass an extraordinary resolution. If you do, you can waive the audit, and you don't need to get anything instead. You still need to prepare financial statements, and you still need to present them to the members. For an organization with annual revenue between 100,000 and 500,000 in annual revenue, it starts to matter, are you a public benefit corporation or not? If you're not a public benefit corporation, then again, you can pass an extraordinary resolution, waive the audit, and all you need to do is present the financial statements to the members. If you are a public benefit corporation, it starts to change. You can pass the extraordinary resolution, waive the audit, but now you need to get at least a review engagement, and I'll explain what that is in a moment. For organizations with annual revenue above $500,000, you can, by default, you need to get an audit, but you can pass an extraordinary resolution if you're not a public benefit corporation. Okay, if you're not a public benefit corporation and you have annual revenue above $500,000, you can pass an extraordinary resolution, waive the audit, but you need to at least get a review engagement. If you're a public benefit corporation, you have to get an audit. So nothing has changed for you if you're a public benefit corporation with annual revenue above $500,000. So what is the difference between an audit and a review engagement? An audit is a CPA, a chartered professional accountant, coming in, looking at your source documents, like your receipts and invoices and so on, looking at your financial policies, like your signing authorities, looking at your financial statements, like your cash flow, your balance sheet, etc. And based on all of that, concluding whether or not they can provide reasonable assurance that your financial statements are a reliable reflection of your organization's financial position. A review engagement, by contrast, is faster, it's cheaper, though how much cheaper depends on where you are. And it's a CPA still coming in, looking at your source documents, looking at your financial policies, looking at your financial statements. But at the end of the day, they're not providing the same level of assurance. What they're concluding is whether or not your financial statements are a plausible reflection of your financial position. Plausible just means that they didn't see any red flags in the limited amount of review that they did. So for some organizations that are smaller, this may be a perfectly fine standard of financial review. It may be perfectly reasonable for you. And if you're getting an audit currently every year, it may be cheaper to switch to review engagement. For other organizations, they or their funders may prefer the higher standard embodied by an audit. It's for each organization to decide what's appropriate for you. And then lastly, I'll talk about the Ontario Business Registry. So when ONCA took effect on October 19th, 2021, a new registry also came online, just so you have another acronym for today, the OBR. And this registry allows you to do many things. It allows you to order a corporate profile. So this will tell you who the government has on file for you as your directors and your current address. And that's important to know, because if it's out of date, you're going to want to update that as part of this transition process. You're required to update the government when any directors change or any officers change, or if your address changes, you're required to update the government. And you do this by filing what's called a notice of change. You can now do that online through the Ontario Business Registry. And even if nothing changes, you're required to file an annual return, just saying nothing's changed in our directors, officers, or address. And now you can do that online. You're also able, through this online system, to make changes to your articles. As I'll explain later, your bylaws do not need to be filed with the government of Ontario, but your changes to your articles do, and you can now do that online. So it allows you to do a whole bunch of things. If you are a registered charity, it's not a replacement for anything you need to file with the Canada Revenue Agency, the CRA. Now, I put this disclaimer here. There are glitches to watch out when the system first came online. I'm happy to report that the government's actually recently quite improved the system. So a lot of these glitches have actually been handled. There are still some issues, so just be mindful of that. There is a helpline for Service Ontario that you can find at the bottom of the Ontario Business Registry page. Okay, I'm going to pause here for questions before we continue on with the steps in the process.
Great, thank you, Benjamin. I'm just keeping an eye in the chat. If anyone has questions, please unmute or put them in the chat. And while we're waiting on that, I have questions for you. Because sometimes as artists will be very engaged in what our practice is, and some of the terminology can get confusing. So or the acronyms. So just to recap, you mentioned PGT. Is that the Office of a Public Guardian and Trustee?
That's correct. And thank you. I should have spelled that out.
Okay, we can put that in the chat, no problem. And another term that you used was extraordinary resolution. And so I don't know if anyone else was Googling that, but can you walk us through what that means? Because in context, it makes sense, but then there's the term extraordinary. So just wanted to make sure people aren't getting lost in terminology.
Sure. So an ordinary resolution is a motion passed at a members' meeting, and unless your bylaws say otherwise, gets a 50% plus one support, a simple majority support. An extraordinary resolution is a motion passed typically at a members' meeting, but you need 80% or more support. Okay, so 80% or more of the votes cast at the meeting are in favor. That's what you need to pass an extraordinary resolution. You can also pass an extraordinary resolution outside of a members' meeting by getting unanimous written support from all voting members entitled to vote on it.
Wonderful, thank you. Last thing that came to mind for me is as we're trying to implement these changes, and you may be planning to speak to this, how organizations can do that. I know in the cases of some of the organizations I've worked with, we've had a committee where we've done it together, and other organizations were fortunate enough to have some lawyers as members who support the process. So I don't know if you have any suggestions there based on some of the organizations that you've worked with that might be helpful to our participants today.
Yeah, so that's a great question to set up this next section, because we're going to go through the process, but the question is, who carries out this process? So the answer is, in theory, it could be anybody. It could be a single individual on the board. It could be a single volunteer not on the board. It could be a staff member if you have a staff member. Anybody could do it. From my perspective, what might be helpful is the following. Remember what I said earlier, that compliance is not really about what you put in your documents. It's about how you take what's in your documents and actually integrate it into your practice. So the question is, how do you set yourself up for success in practice before you've even put it into your documents? And what I have found useful is if the people who are going to have to live with the rules are part of making it, okay, this is a pretty fundamental democratic principle. If the people who are going to have to live with the rules are part of making it, they're more likely to follow it for a couple of reasons. Number one, they're more likely to view those rules as legitimate because they had some say in it. Number two, those rules are more likely to actually reflect their realities. And that's probably the more fundamental point. They're more likely to be practical for those people, to reflect their values, etc. And so if you are, for example, making rules about members' meetings, well, including some of the people who come to members' meetings, right? If you're making rules about the board, making sure somebody on the board, is part of that discussion, etc., then it sets up those rules that any changes you're making to be more realistic for those people. So that's who you may consult with, or who may make up a committee if you decide to do it by committee. In terms of who leads the process, there's no one right answer. It varies by organization, but there are two warnings I'll share. So number one, if you do have lawyers involved, which can be a blessing and a curse, right? I'm sure we've all had that experience. Um, Something to keep in mind. It can be tempting to just hand it to a lawyer and say, just do it for us. We're busy, we're doing the actual work, you just take care of the paperwork. And that's fine. And they can generate a set of legally compliant governing documents for you if they're competent in this area. But if you're not careful to make sure that they're actually consulting with everybody, they may come up with something that makes sense to them as a lawyer that makes sense to nobody else, right? They may go off on their merry way and move out of town or whatever it is, and you're stuck with this document that nobody understands and nobody's read it because nobody was part of that process. So if you're giving it to a lawyer to lead the process, I would say make sure there's some kind of participatory element, and that they're really acquainted with the culture and values of your organization and know how to talk to the people within your organization and use terminology, for example, and avoid acronyms that don't make sense to the community. So avoid the temptation of just thinking you can just hand it off to a lawyer. The second thing is the other habit that I've observed nonprofits fall into is there's one keener. There's one keener on the board, or there's one keener, he or she or they just love the governing document stuff and nobody else does. So why not give it to them? And that can be great, but it can have issues in the long term for the succession and continuity of the organization. Because, God forbid, what happens if something happens to that person tomorrow? They get hit by a bus. What happens to all that institutional knowledge? If it's just them and it just sits with them, they're likely over time an unhealthy level of dependence will develop, and all the questions about the governing documents will go to them, etc. And they could be perfectly well motivated and perfectly good, but that it still isn't healthy over the long run for the continuity of an organization. If we're committed, and organizations have different lifespans, but if we're committed to creating a community that we want to be around in 10 years, 20 years, 30 years, we need to be thinking about our governance structures in ways that, how are they going to make sense? How are they going to be transmitted to leaders 10 years down the road, 20 years down the road, 30 years down the road? And generally speaking, overly relying on the keener is not a good strategy to do that. So to summarize, no one right answer, but include people in the process who are going to have to live with it, and don't overly rely either on lawyers or on keeners, who are wonderful people, I'm sure, and contribute lots to the organization. Thank you, Erin, for summarizing in the chat. That's very helpful. All right, so what are the steps? So number one, figure out whether ONCA applies to you. I alluded to this at the beginning, but some people have joined us since then, so I'll just reiterate. ONCA applies to nonprofits that are incorporated under Ontario's Corporations Act and most special acts. So if there happens to be an organization in the room today who there was an act created just for them, this tends to be older organizations, or a special act just for organizations like them, for example, the Ontario Historical Society Act. Then ONCA would still apply, but it would apply in conjunction with that special act. Okay, if you have specific questions in this area, I can field it, but it doesn't apply to most nonprofits. ONCA does not apply if you are federally incorporated under the Canada Not-for-Profit Corporations Act, if you are a cooperative corporation under the Cooperative Corporations Act. If you are a business corporation that just happens to run on a nonprofit basis, ONCA does not apply to you. If you are unincorporated, ONCA does not apply to you, but if you wanted to become incorporated, you could incorporate under ONCA. If you're a condo corporation, I don't think that's an issue for this crowd, but if you happen to know any condos, you can tell them ONCA does not apply to them. Okay, so you figured out ONCA applies to you. Next, when do you do all this? So here's the general window of time, and here's how long it might take within that. So ONCA took effect on October 19th, 2021. I already said that a couple of times. So we're in this transition period. The question is, what are the rules that apply during this transition period? So by default, your governing documents win. Even if they contradict ONCA during this transition period, the first place to look is your governing documents. As long as they were passed validly before ONCA took effect, they continue to be effective until October 19th, 2024. But if you have a question and your governing documents do not address it, now you're looking to ONCA for an answer. On October 19th, 2024, as I mentioned, the nonprofits governing documents will automatically transition over to be ONCA compliant. What I'll add here is that there are a few exceptions to this. There are a few cases in which ONCA says that things that you may have put in your bylaws, which you could have done before, and that's perfectly fine, now ONCA says you need to move them over to your articles. However, if you have not moved these items over from your bylaws to your articles by October 19th, 2024, then they're still valid as long as you don't make any changes to them. So bottom line, in these items that I'm about to list, you can keep your current structure in your bylaws, but if you ever want to make any changes in the future, you're going to need to move them over to your articles. Now, many lawyers that I know who practice in this area just tell their clients, move it over from your bylaws to your articles now while everybody's paying attention. You do not want to run into a situation 5 years, 10 years down the road where people see these rules in your bylaws and think all I need to do is change it in the bylaws, because that could cause issues. Okay, so what are these rules I've been talking about, these exceptions? Number one, the size of your board. ONCA says you need to put the number of seats on your board, the number of directors, in your articles, not just in your bylaws. Number two, if you have multiple member classes. So I mentioned pretty much all nonprofits are required to have members. You also have the option of having multiple types of members. If you have multiple types of members, that information needs to be specified in your articles. It's not enough just to have them in your bylaws. Number three, voting rights of members. By default, it's one member, one vote, but you have the ability to change that. You can say this group of people have more votes, this group of people have no votes. You can change that, but if you want to change that, you need to do it in your articles. And then finally, and I mentioned this already, if you want a line that says what's going to happen to your property if you dissolve, if your organization ends, then in order for that rule of what's going to happen to the property to be binding on the organization, you need to put it in your articles. All right, so that's the window of time, and that's what some of the exceptions that will even continue to be in effect after October 19th, 2024. How long does it actually take to transition? So estimates I've heard have always been 6 to 12 months. You don't have 6 to 12 months before October 19th, 2024. So what factors may speed up the process? What factors may cause the process to take longer? Number one, the age of your governing documents. If your organization has been around for a while and you have not looked at your governing documents in a while, then chances are there's more that you're going to need to change than just the minimum that ONCA requires. So you'll probably need more time accordingly. But if you've regularly updated your governing documents, this will probably be a narrower exercise. Number two, the capacity within your organization. Obviously, if you have one or more people who can dedicate themselves to this task, that may speed up the process. If you can seek external counsel, that may speed up the process, etc. One thing I'll note is that another element of capacity is has your board actually read the governing documents before, right? If the answer is no, there may be a learning curve, right? So the earlier you get them to review the governing documents, which is something they're actually required to do anyway, all the time, not just because of ONCA, the earlier you get them conversant, feeling comfortable with the governing documents, the smoother the process will be when they're asked to vote and discuss these issues and so on. Level of consensus. So Erin mentioned that sometimes this ONCA process highlights a whole bunch of questions that are maybe good questions entirely independent of ONCA. Sometimes an organization makes certain governance decisions, for example, requirements to be on the board or requirements to be a member that maybe some people weren't happy with, but it was accepted. Now, as part of the ONCA process, all this dust is being kicked up. And maybe there are some old disagreements between the members or between directors or between the board and members. So the more disagreement there is, usually the longer it takes to build that consensus. Now, taking the time to build that consensus can be a really constructive process for an organization because you'll end up with rules that are more acceptable in general and that will last longer. And letting these disagreements kind of simmer can have some destructive effects in the organization if there's ever, a break for other reasons. So taking time to build consensus can take longer, but I guess there are shortcuts if you're willing to skip over the consensus building. And then finally, how easy is it for you to call a members meeting? If you basically have to wait until your next annual general meeting, that's going to delay the process somewhat. But if you're willing or able to call a special members meeting, then that can speed up the process. Now, you may say, well, we can hardly get anybody to come out to anything as far as members meetings goes. How are we going to speed up this process? So here are a few ideas. So number one, make it fun. Feed people. That gets people out. I spoke with a dance company, a children's dance company once, and they said they had their members meetings in the intermission during the recital. Okay, so all the parents come out to see the kids dance, everybody's happy, and enough people stay in the room during the intermission, and you can deal with your business there, right? And if you've dealt with all the questions in the committees and discussion and given lots of people opportunity to participate outside, the actual members meeting doesn't have to be so long and robust and have so much back and forth. If you've done all the work ahead of time to build that consensus, when you get into the room, maybe it could actually be done during an intermission at an event everyone's happy to attend otherwise. That's just one strategy. There are many. Bottom line, make the members meeting appealing for other reasons. And I've already spoken a bit about how best to work with a lawyer and not to fool yourself into thinking they can just do it for you. One thing I'll add here, because I get asked this question, do you have to work with a lawyer? The answer is no. You don't need to get a lawyer to sign off on your governing documents, for example. You can do this yourself. A lawyer may add value if, for example, there are significant assets in your organization or there's significant risk of dispute in the near future. So if there are factions on your board or within your membership, so you can imagine things going awry pretty easily, you may want to take additional care in dotting all your I's and crossing all your T's. But whether that value is worth the cost of a lawyer depends on the lawyer, depends on the organization, etc. So it's really up to you. Okay, the next step, if you've decided, okay, now's the time to act, get your books and records in order. What are some examples of records you may need or want? Number one, your letters patent or supplementary letters patent. And you can actually order a copy of this from the Ontario Business Registry if you don't have a copy of your letters patent or any supplementary letters patent. What's a supplementary letters patent? If you ever filed for changes to your letters patent, the government would not have sent you a new letters patent. It would have sent you these supplements that are basically addendums. So here's your letters patent. Here are the addendums. You have to read them together in order to know what your rules actually are. Number two, your bylaws, not just your current set of bylaws, but past versions as well. You're required to keep them. Number three, your minute books. Nonprofits under ONCA are required to keep minutes for 4 kinds of meetings. Number one, board meetings. Number two, board committee meetings. Number three, members meetings. Number four, member committee meetings. These minutes can be kept virtual, as can pretty much all your records under ONCA, as long as they are accessible from some location within Ontario, either your registered address, or an address appointed by the board. Special resolutions. So we've talked about ordinary resolutions. We've talked about extraordinary resolutions. What are special resolutions? So they're the step in between. An ordinary resolution is a resolution passed at a members meeting with simple majority. A special resolution is a 2/3 majority resolution. If something needed a 2/3 majority, probably it was important. It's either a change in name or a change in purposes or a change in the structure of your organization or something like that. So if you have any of these, you may not, but if you have any of these, it's important to know what they say. Probably. Directors and officers register and members register. Register here is just a fancy legal word for list. You're required to keep a list of your directors and officers and a list of your members. This list needs to have their names, their start date, their end date. So it goes back 6 years for the members and indefinitely for the directors and officers. So you need to put their start date and their end date. Their address for service. So this doesn't have to be their personal address. It's the address where they agree to receive official documents from the nonprofit. And that could even be the nonprofit's own address. If they are, unhoused individuals, they can pick up documents at the nonprofit's location, and that's fine. That meets the legal requirements. And if they agree to receive documents electronically, their email address. In the case of officers, what their title is, and if you have multiple classes of members, what class of member each member is. Okay, this is the bare minimum information that your register needs to include, and it needs to be complete at all times because you need to know who has what rights in your organization. For example, who's entitled to receive a notice of members meeting, or who's entitled to submit a proposal to those meetings, and so on. Director consent forms. ONCA requires that people who are elected to be directors sign a consent. So it's not enough just to elect somebody to be a director. Otherwise, you could elect anybody. As I like to say, you could elect Keanu Reeves to be on your board, and then 4 years later, call up Keanu and say, haha, you've been liable this whole time. You're not allowed to do that. You need to get Keanu's autograph. This form, and there's an example on our website, something that I'll put in the chat now, and I'll also tell you more about later, nonprofitlaw.cleo.on.ca. If you search on the website director consent, you'll find an example of this form. It doesn't need to be a fancy form. It just needs to express that the director agrees to be a director of the organization, and the date and their address and their signature, so we know who we're talking about. While this is the legal minimum, you can also use this opportunity of consent to make it more emphatic consent or more meaningful consent by really sitting down with the director and explaining to them, what does it mean to be a director? What are the duties? What's expected of them? This can be a valuable part of the onboarding process. You can also use this as an opportunity to get them to consent to other things, such as a code of conduct, an equity policy, a privacy policy, confidentiality, etc. So you can make this more robust, although ONCA doesn't require that. And then finally, your annual revenue. It's important to know your annual revenue, to know, are you a public benefit corporation or not? What level of financial review are you required? Make sure the government has the right address on file, and you can do this by going to the Ontario Business Registry, searching your organization, and ordering a corporate profile. Previously, before ONCA, your organization could give the government a PO box as your address, which might have made sense if you didn't have a fixed address for your work. That's no longer allowed, unfortunately. We totally recognize that this unfairly impacts smaller organizations, rural organizations, precariously, housed organizations, etc. We have actively brought this up to the government several times. So far, they have not changed this policy. If you're in that situation where you don't have a fixed address and you're wondering what address should you give the government, here are a few common workarounds. So number one, you could give the address of a director or an officer. Now, that address is going to be publicly searchable for the nonprofit, so that needs to be something they're comfortable with. And just note that your directors and officers may change frequently, so you would need to also change the address maybe frequently. Number two, some shared spaces, such as the 10C in Guelph or the Center for Social Innovation in Toronto, offer mailbox services to the members, so that could be an option. Some community centers also offer mailbox services, so that might be something to discuss with your municipality. And number three, if you have worked with a lawyer or an accountant, either on a volunteer basis or on a paid basis, many offer mailbox services in that respect as well. Okay, reviewing your bylaws. So what might you actually need to change in your governing documents? Here are 5 examples. Previously, you were required to appoint a president and a secretary. That's no longer required, though you're still welcome to do that. Now you're required to appoint a chair, and that chair needs to be a director on your board. You could put that in your bylaws, although you don't have to. The rule applies to you regardless. Number 2, who qualifies as a member, it can be much more flexible. For example, you could allow corporations to be eligible for membership, which might be a way to build accountability to other community organizations in your area. You could be actually quite flexible in who you allow to be a member. But if you want to, you would need to spell it out in your bylaws. Number 3, if you have multiple classes of members, and remember that would need to go in your articles, in your bylaws, you need to specify how to join each class, how membership in each class ends, and how to withdraw or transfer between classes. Number 4, members have lots of new rights under ONCA. One of these rights is that members who control 10% of the vote in your organization can go to the board and demand a membership meeting. You cannot make this a higher threshold. For example, your bylaws may say 20% of the members are required to demand a members meeting. That would no longer be valid. You can, however, say in your bylaws that this right is easier to exercise. You can say 1% of the members can demand a membership meeting, or 5%. You can lower it. Number 5, proxy voting. Proxy voting means someone cannot or does not want to attend your members' meeting, so they appoint somebody else to vote on their behalf. This is an example of a way to make your meetings more accessible, potentially. By default, proxy voting is not allowed. If you want to allow proxy voting, you have to actively say that in your governing documents. What might you want to change in your articles? And how do you actually change your articles? You change your articles by filing what are called articles of amendment. So you're not writing new articles and then submitting them to the government. You're filling out a form called articles of amendment and submitting it to the government. And I'll say in a few slides how to do that. So number 1, you may want to change your purposes, not because that's part of the ONCA transition process, but maybe you've found that it's been a long time and your organization does different things now, or maybe the language is outdated and no longer reflects the values of the organization, or what have you. So if you're making changes to your articles anyway, maybe this is a good opportunity to make changes to your purposes. Note, if you're a registered charity, changing your purposes can affect your charitable status, so you may want to seek legal advice, or at least the views of the Canada Revenue Agency, the CRA, which they may give it or not. Number 2, number of directors. I mentioned the size of your board needs to be in your articles now. You could either have a fixed number, such as 7 or 19 or 12 or whatever, or a range like 3 to 24 or 5 to 26. The minimum, that whatever number you give, it needs to be at least 3. Membership classes and voting rights. As I've said before, if you have more than one class, you would need to say that in the articles. And if you want to vary their rights from one member, one vote, you would need to say that in the articles. If you want to restrict your nonprofit's powers, for example, you want to say we're never going to sell this particular building or this piece of land, or we're never going to borrow without security, then you would need to do that in the articles. It's not enough to do it in the bylaws. Okay, what's the actual approval process? Disclaimer, the process I'm about to describe is a default process, meaning this is the process unless your governing documents alter it in some way, which they could. The one thing your governing documents could not alter is that the members have the final say. Okay, so firstly, somebody proposes the changes to the board. As we've talked about before, it could be anybody. If you are looking for help from a lawyer, I'll just note one of the resources on our website is a directory of lawyers. We do not vet these lawyers. We do not recommend them. We just confirm some part of their practice includes nonprofit law. So someone proposes the issue to the changes to the board. The board then votes. When they vote on changes to bylaws, unless the board resolution says otherwise, those changes take effect immediately. Okay, but they're only effective temporarily up until the next members' meeting. When the board votes on changes to the articles, they do not take effect. What they're voting on is proposing these changes to the members. So either way, the next step is you need to have a members meeting. It could be either an annual members meeting or a special members meeting called for this purpose. In order to have a valid members meeting, you need to send out proper notice. And the default notice is 10 to 50 days in advance. Your bylaws may specify something else. They may say 21 days or 20 to 30 days, but it needs to be within that 10 to 50 day period. Number 2, the notice needs to include sufficient detail to allow your members to form a reasoned opinion. Whether or not they do is up to them, but you need to provide them with the detail. Number 3, notice needs to be sent out individually to each member. How you do this may depend on what your bylaws say. For example, they may say it has to be by mail or has to be in person or in a particular way. But if they say nothing, you could do it online by email. If you have their emails, you could do it in person by hand delivering it to them. You could do it by mail. That's really up to you. But it's not enough, for example, just to post on Facebook or Instagram, we're having a members meeting. It needs to be sent in some way individually to everyone who's entitled to get the notice. Once you've sent out proper notice, there needs to be quorum at the members' meeting. The default quorum under ONCA is 50% plus one of your members. You may say 50% plus one? Who could get that kind of attendance? Relax, this is just a default. In your bylaws, you can vary this. You can make it as low as you want, as high as you want. You could make it a percentage. For example, you could say 1% of our members need to attend, or you could say one member needs to attend. Now, note, these are the options available to you. I don't necessarily recommend any particular thing. The lower you make your quorum, the less accountability there is, though it may be easier to have the meeting. So there are trade-offs. Okay, so let's say you have quorum, then you vote. Unless your bylaws say otherwise, a regular vote to change your bylaws is 50% plus one. A vote to change your articles is a 2/3 majority. In both cases, when I say 50% plus one or 2/3, I mean of the votes cast at the members' meeting. Once your members have passed the changes to your bylaws, you are done that part. If you're a registered charity, you would need to file the updated documents with the CRA. All right, second last slide. You do, if you make changes to your articles, need to file them with the Government of Ontario. There are 3 ways to do this. Through the Ontario Business Registry, by downloading a form from the Ontario Forms repository and mailing it in, or through a third-party provider. If you want to do either option 1 or 2, you need to order a company key. You can do that by going to the Ontario Business Registry website, typing in your address, or if you don't have an up-to-date address, typing your email address and ordering a company key from the government. It takes a few weeks, so just hold on. I'll just conclude before I pause for any last-minute questions by noting we have many resources on our website to help you. We have from information pages to sample bylaws to a bylaw builder that can help you create bylaws from scratch that we've actually user tested to be more inviting in how they look and feel and so on. We have a glossary, and you can email me, and I can provide you with general legal information, but not legal advice. So here is my email. With that, thank you so much for your time and attention, and I do hope this is a constructive process for your organizations. Are there any last questions?
I'm just scanning the chat, and again, if anyone has questions, please put them in the chat or unmute. That was so much information, Benjamin. Thank you so much. I included a link to some of the terms you mentioned as well, because I recognize for many of us that are active artists, some of the terms we may need to just kind of take a moment and get ourselves familiar with. So I encourage everyone to do that. And while we're waiting on any other questions, I have questions for you. And we had the benefit of communicating ahead of time. And you mentioned having worked with many organizations, many of which have been IBPOC organizations, and how some of the things that happen within governance can disproportionately impact an IBPOC organization. You've mentioned some solutions, for instance, like having a fixed address, using a post office box. And I think you mentioned, what was it? The Canadian Centre for Social Innovation.
The Centre for Social Innovation is in Toronto, but there are other examples of shared spaces around Ontario.
No. And are there any other considerations or things that you've seen in working with so many organizations that may need to be taken into consideration from an IBPOC standpoint? Something that just a heads up or those kind of things?
I would just say that for organizations that are engaged in any kind of cultural resurgence activities, for example, or are view their work as part of defining the autonomy of their people, or they view it in through a self-governance lens. That number one, a lot of the things that we think are law are not actually law. There is much more flexibility in how we define our governance and the terms we use and the way our governing documents look than we realize. And I would just highlight that this exaggeration of what is actually law is part of a kind of self-policing. And so I would invite organizations to consider, what are other, what other titles we could use? How could we better reflect our practices and values and so on in how we make decisions, in how we define who's a member and who's not a member, and the qualifications for directors. These are some examples I alluded to that I've seen come up for other IBPOC organizations. And just really the high level message is there's more flexibility than you think.
That's very helpful. Thank you. It also brings to mind, as you were talking, how many organizations will partner with one another and support one another in terms of having an address, or supporting one another in terms of how they govern themselves, and sharing that knowledge and innovation, so we're not reinventing the wheel.
Yep.
So those are very helpful. So any other questions, anyone? I don't see anything coming up in the chat. I recognize there's a lot of information and there's probably still processing. I know I'm learning something each time, and I want to thank you, because having served on a few boards where I've looked at these things, I want to encourage others to find out more and to get involved, and some great ideas, feeding people and finding innovative ways to have those meetings engaged with other things does draw people in. We've done it by pairing it with when we show what the new season is. And so people are engaged in that, and they learn about the governance side of it as well. And once you get engaged, you tend not to step away. I can say that from my own experience. So Benjamin, thank you so much. Again, learning more each and every day on this. And I want to encourage everyone to take advantage of the resources that Benjamin has shared.
Thank you so much for having me. It's been a pleasure. I hope everyone has a great conference.
Thank you, Benjamin, and thank you so much, Erin. I think what's also beautiful about what you've communicated, Ben, is the importance of arts organizations to make it the bylaws as active and as beautiful and artistic as they choose. So I think sometimes these are like white paper documents that artists and arts organizations have that becomes these really boring and scary things, because we also work in a different way. And so it's really interesting to hear that, and to also think about what this idea of placemaking is. And could this idea of placemaking in the arts also arrive in what is your bylaws? What does that look like? So thank you so much for those that very informative aspects of this as well. I know it's still scary. I run a not-for-profit organization, and sometimes I'm like, oh my goodness, here's another set of legislation that, we don't have the capacity, many organizations, to execute these things. But I think it's also, you mentioned this idea of like layering it and the strategy involved in strategically working at it over a course of time. And so thank you so much for that as well.